This case has to do with obtaining medical treatment for your kids. Unfortunately, the child that was born in this case was born substance-afflicted and was born with multiple medical issues. Hi, my name is Erica Benson. I'm an attorney here at Cape Fear Family Law, and I'm here today to talk to you about a recent Court of Appeals decision that was published on August 20th of 2024. This case has to do with obtaining medical treatment for your kids. Unfortunately, the child that was born in this case was born substance-afflicted and was born with multiple medical issues, jaundice, positive for amphetamines and methamphetamines, amongst other things. This is a really tough case because mom did obtain some medical care for the child, but the Court of Appeals found that it simply wasn't enough. She was canceling appointments, not bringing the child, sometimes not showing up at all. The hard part about these cases is that the Department of Social Services, when they become involved in your life, they will give you a chance to show that you are trying to obtain this care for your child and to essentially reverse course a little bit on what's happened already. Unfortunately, in this case, mom didn't do that, and she continued to miss these appointments and continued to cancel them. And it got to the point where the department had to remove the child to ensure the child's safety and to ensure that the child obtained the medical care that it needed. Jana Gemmel is on the other side of the camera here. She disagrees with me and my analysis of this case because she's seen this from the same point of view as the Department of Social Services. Mom missed 24 out of 41 medical appointments for this child. This is not, mom was running late and couldn't make one appointment. This was a deliberate act on mom's part to skip these appointments. And truthfully, it's probably because mom was taking substances and was not in the right mindset herself and probably needed medical treatment and mental health services herself. All of that to say is that it's not that mom wasn't sympathetic. Mom claimed that part of the reason she missed all of these appointments is because she didn't have transportation. Mom had access to Medicaid, which does provide some transportation options, but we all know it's never enough. She's always going to have these issues until she can get on her feet and obtain her own transportation. The Department of Social Services does typically help with this and will provide some transportation, but again, the social workers are not an Uber, so they can't provide transportation for everything. It seems to be the crux of the issue in a lot of DSS cases that we have, where based on the opinion, it does seem that mom was making some efforts to get to these appointments. What she claimed in court was that she did not have a vehicle or transportation available to her to get to these appointments. Obviously, we know in rural places in North Carolina, that can pose a pretty big issue. She does seem to have access to Medicaid, which would have provided some transportation options, but we just know that that's never enough. The court found that mom's transportation issues, her inability for whatever reason to get this child to the medical appointments that he needed, to include hernia surgery, resulted in the neglect of this child. The child truly needed these medical procedures and appointments, and they just weren't happening. It was the inconsistency here that really created the problem. The child was going to some appointments, but as I said, missed 24 out of 41 of the appointments. The inconsistency is really what the Court of Appeals leaned on in determining that there was neglect here. Another thing that the Court of Appeals noted here was mom's substance abuse issues. We know that mom had substance abuse issues because the child tested positive at birth for amphetamines and methamphetamines. The difficult part with this is that the court won't necessarily hold it against you that you have substance abuse issues. The Department of Social Services in most cases is required to help you obtain mental health and substance use treatment for that. However, you have to utilize those services when they're offered to you. You might be wondering what the outcome of this case was, and truthfully, we don't really know. We know what the Court of Appeals said, and what they said was that this child was neglected, but even after finding a child is neglected, and even after the child being removed from mom, typically the department is required to make efforts to help reunify the parent and the child. So mom could be obtaining these services that she needs right now. She can be working on her substance use, and she may be able to get this child back, and that's what we hope for her, and that's what we try and do here at Cape Fear Family Law. Cases with the Department of Social Services are really unique. We're obviously in an adversarial system. Most times you don't just bend to the will of the other side in a lawsuit. However, in cases with DSS, that's essentially what you need to do. If DSS is asking you to do certain things or utilize certain services in order to get your kids back or help with reunification, that really is the best path to do that. At the end of the day, even though, as I said, it is an adversarial system, the department really does want these parents to be able to reunify with their kids. In part, it's because having all of these kids in the care of the state is a massive strain on the system. There is not money, foster parents, transportation, there is not enough of this to go around. And so the department really wants parents to step up, do what they need to do, and reunify with their kids when it's safe and in the best interest of the child. If you've had dealings with the Department of Social Services, post below, tell us what your experience was like. Were you able to reunify with your kids? Maybe you obtained these services before your kids were removed and you never had to go to court. Let us know what it was like below.